I'd like to introduce our next afternoon keynote presentation here at the Planet MicroCap Showcase Vegas 2024. It's our good friend, colleague. Very thankful for your sponsorship. And yeah, he's doing a topic titled Hot Topics in SEC and FINRA Enforcement Matters by Jon Uretsky from PULLP.
Hey, everybody. Thank you for being here. So just quick show of hands, want to just get a little bit of fun before we get into it. Who here works at a public company? Who here invests in public companies? Who here provides liquidity through lending to public companies? Who here is with a broker-dealer or an investment bank that works with public companies? All right. So here's the thing. If you raised your hand to any of those questions, the SEC Enforcement Division and FINRA's Enforcement Division, they are both out to make things harder for you. And that's everything. Planet MicroCap in general. What does that mean? It means some good marketing, Shelley. It does. But really what that means is that this is the industry that for one reason or another has sort of just been deemed a problem by the enforcement people. Now, first, I want to back up a little bit. I'm Jon Uretsky. I'm one of the partners in PULLP. PULLP is a full-service securities law firm, but our real specialty, and one that you're not going to see really from any of the other law firms here, is the litigation side. So that's what I'm going to focus on today. We do lots of other things, but where we really make the bread and butter work, that's the microcap litigation space. So what does that mean? That means that sometimes you have those cases where you have a lender suing the public company because they didn't have the money to get them back, to pay them back. Okay. Sometimes we have the public company. Sometimes we have the lender. Okay. Sometimes the SEC goes after that lender. Sometimes the SEC goes after that public company. Now, there's also the chance that maybe everything works out great. Well, then there's these shares, and someone's going to want to get rid of them. How are they going to get rid of them? Well, the SEC tends to go after the broker-dealers or whoever else it might be who helps you try to get rid of them. And that's the real problem. If none of that can happen, there's no good way to make any money. And if there's no good way for this space to make any money, there's not even any room for the accountants and the IR guys and the lawyers, frankly, all of us. This entire Planet MicroCap space, it's a big problem. And that's what I'd like to really talk about today, the hot topics. There's a big, huge, amount, and I'll get to that at the end, that SEC enforcement has done. But I'm going to try to focus on three different sort of areas, and they're sort of the topics I ran through at the beginning. So first, the SEC has recently started bringing a lot of cases against lenders, against the convertible debt groups. And that's important, and I'll get there and I'll tell you why. Now, again, nothing's changed. They're also bringing a lot of cases against public companies. That's the majority of everybody here. And whether you're an officer, whether you're a director, whether you're a consultant to one of those guys, whether you're a private company who wants to get there, no matter what, that's still the problem and their goal. And by their goal, I mean SEC enforcement. And then it's against the broker dealers and the investment banks. And you may not see as much why that's important. It's also done by FINRA instead, but we'll get there at the end. The spoiler alert, the reason it's important is no one's going to be able to make any money if you get shares. And I don't care how you're going to get them. Let's say you got shares through lending and you have convertible debt. Let's say it was just a regular transaction. Let's say you're a founder. I don't care how you got your shares. You have your shares. Sell them. Oh, you can't? That's FINRA's goal. That's the SEC's goal. If you can't make any money, you're not going to be here. You're not going to be looking to meet other people in the microcap space. How are they going about trying to reach that goal? And why would they go about trying to reach that goal? Well, again, the reason that they're trying to come up with ways to stop it is because, right or wrong, they have deemed microcap, penny stock people as problematic. Okay. I don't want to be offensive. I'm not the one calling you guys problems. We've been in this space. My firm's 20 years old. We've done nothing but microcap that whole entire time. Even before I started that firm, I go back to the 90s, and it was always viewed as that's where the problems were. Now, I've worked for bigger companies. I have noticed no difference. There's no real difference in the habits of the big broker dealers, of the guys at the big public companies. There's no difference. If you invest in a big company, guess what? Your motives are the same. You want to make money. Your methods might be a little bit different just because there's different ways of doing it in the microcap space, but there's not the same enforcement target on the big guys that there is on the microcap space. Now, I mentioned I had the 3 different categories. So let's talk about why that trinity is important. And it starts with the basics. You're a public company, right? Or you're an investor in a public company. What do you always need? Money. We've worked with them for a long time. No public company we ever work with doesn't end up needing money. And you know what they can't do? Walk into Citibank, walk into Goldman Sachs. You go there, they're not going to give you good terms on a loan. They're barely going to give you a loan. They're barely going to give you the time of day. Where are you going to get your money from? Well, they're sitting out in the, go downstairs, I guess, first. But, you know, that's where they are. Those guys, the sponsors here, they're the ones who give out the money. You're going to have to go to those kind of banks, those kind of broker dealers. And yeah, you're going to have to do Reg A's, different types of transactions. You know what you can't do is just be Google. That's the microcap space. Well, what if your enforcement and you could take away that money, all those sources of money? Well, that would dry up microcap. So what if they started going after those broker dealers? And they have. And what if those broker dealers weren't allowed to help you sell the shares anymore? Would you give any money, whether you're an investor or a lender, to a public company if you can't make any money? And the answer is, of course not. They don't even need to win. They just need to turn off the faucet. By going after the broker dealers, by going after the lenders, by going after the public companies, and by going after the officers and directors and investors, they can take out the entire space. There are vast changes coming to the structure of microcap financing, and it is by design. So I mentioned that at PULP, we have a good pulse on what's going on with the 2 enforcement divisions, but I'm not sure, I may have just gotten to this a little too fast. I want to explain the difference between enforcement and the actual organizations. So at both of them, there's sort of the people who make the rules. At the SEC, let's focus on them. There's the 5 commissioners, right? They're appointed by the president. It's an agency. It's like any other government agency. And they make rules. And they do so slow, and they do a lot of other things. But what they don't do, they don't initiate a case. They don't say, you know what, let's go sue that public company. They don't say, you know what, that officer and director right there, let's go after him. They have an outside law firm for all intents and purposes, just like us. Only they call it SEC enforcement. Those people are the client, meaning the commissioners. They are the client of SEC enforcement. And it works the same way at FINRA. FINRA itself makes rules. FINRA itself does a lot of regulation, but FINRA enforcement, they're effectively an outside law firm that does the litigation for FINRA. The SEC enforcement division is not the SEC itself. What that means, we often will come to a settlement. We'll reach a settlement, and what do they say? Well, you know what? Let me go check it with my client. And who do they mean? They mean the SEC. You have to always be aware you're not actually dealing with the SEC. You're not actually dealing with FINRA. And this is important because sometimes what you get, and it's a very common expression, is what's called litigation by enforcement. It takes a long time for them to make those rules. It takes no time for them to just wake up one day, file a lawsuit. And then what are you thinking? You're thinking, but that's not in the rule. That's not even the way it's ever been. It's been that way for 90 years. What are you talking about? And honestly, we see it as litigators. We're just like, well, but that's what they're alleging. I guess we have to fight that fight. And if you're a small public company, if you're a microcap public company, sometimes that press release alone is enough to keep people from investing in you. It ruins transactions. That's intentional. So if we can have regulation by enforcement, what we're really worried about here is enforcement. But as I begin with that first topic, the lenders, I just want to kind of give you some background. For about 90 years, this all began, the legal structure, in 1934 when they came out with the Exchange Act. And I'm not good at math, but I think that was roughly 90 years ago. Probably every single one of you thinks I'm stupid and wrong, and I'll take it. In any event, that whole time, up until COVID started, it was really well understood that a dealer is just somebody who takes the other side of a customer's trade, using their own account to do that. And what the SEC says now, what SEC enforcement said as of COVID is, no, forget about all of that. If you're a business and you buy and sell for your own account and you do it regularly, guess what? You're a dealer. 90 years, we changed our mind. There's literally a guy who we have worked with at SEC enforcement in Utah who woke up one day and had an idea. And kind of astonishingly, it's worked. They've had a lot of success. Now, to be fair, that was the beginning of COVID. So that was early 2020. It was February 6th of 2024 when the regulator itself, the arm of the SEC that makes the rules, when they actually got around to changing the rule to catch up a little bit to enforcement. But this is important because now there is a new rule, it's in effect, and it expands the definition of a dealer, meaning if there's a regular pattern, I'm reading from the rule now, if there's a regular pattern of buying and selling securities that has the effect of providing liquidity to other market participants. Anybody here know someone who that could apply to? Anybody here potentially, could that apply to you? Does anybody here think that's fair? Because I don't. There's obviously dealers. And I think we can all just picture what a dealer is, and it's what a dealer has always historically been. But no, now you need to register. Basically, if you're a guy downstairs wearing your boxer shorts and you make 1 or 2 trades a day, but you do it regularly, well, you're apparently the same as, I don't know, name your biggest broker dealer you can think of, Merrill Lynch maybe, somebody like that. There's no difference to the enforcement guys. Why? Why would that be? And again, it has nothing to do with registration. It's how can we take this out? How can we keep the money from going to the public companies? Basically, I don't remember who raised their hand, but everybody here who invests in a public company, how can they help keep money away from your public companies? Well, you know that a lot of them have money that they get from lenders, convertible debt guys. And if they can just stop those guys, make sure they're not in business, that's one good way of keeping the public companies from getting money. And it worked. What they started with was one of the worst guys in securities ever. His name was Bernie Madoff. No. It was Sam Bankman. No. It was Ibrahim Al-Magharbi. And most people here, you don't know who he is. And that's because he's not a big time player. He was 29. He was actually taking classes in college. He was making like $30,000. And the SEC picked him. Why? He couldn't defend. He didn't have the 30 grand to defend an SEC case against that. We're cheaper than most. We can't do that. He lost. And then, and this is what's key, that precedent allowed SEC enforcement to go after other guys. You've heard of them, Fife, Keener. And then they won, and they won on that. And then to make matters worse, they just February 14th, Valentine's Day of this year, they took it up to the appeals court, that original case. They got an appeals court, the 11th Circuit, to say, yeah, they won. So now not only is there a new rule, but there is really, really bad precedent, is what it's called for lawyers, meaning that all of those dealers, they are probably in a space where they're going to need to register. And if they need to register, they're not going to be in the business anymore, or they'll go overseas. What doesn't jive, though? Registration versus the illegal nature of it. No one ever said, and maybe it should be, by the way, I'm not making a judgment on there. Maybe the convertible debt lending should be illegal. But you know what happened not too long before all this? In 2014, a guy named, who you may have heard of from Octus, Kurt Kramer, he literally took his convertible debt paperwork and he gave it to FINRA. He's like, what do you think? This okay? Guess what FINRA said? This is 2014, not that long before 2020. They said, yeah, looks good to me. And he got to use it. And by the way, I don't know that that's wrong. Is this a problem, FINRA? No, it's not. And then you use it. Sounds good. And he used it. And 6 years later, the SEC said, oh, no, those same papers, like no change other than the name. The PubCo itself changed and maybe some of the terms. Now, it's not that it's illegal. It never was. There's nothing wrong with the trade. There's nothing wrong with that. It's that now you got to register. Why? That's how we're going to take out this industry. And once they got the small guy, they've leveled up to bigger targets. Fife and Keener, we're talking about a lot more money. Now, that was the lenders. Next, I want to talk about actions against public companies themselves. So, all right, so we're not going to do convertible debt. You're a public company and you need money somehow. How are you going to get it? Well, luckily, we know that there's this relatively new way of getting money, right? Reg A. Who's here? You heard of Reg A, right? No problem? Raise your hand. Reg A should be fine, right? The SEC wouldn't have a problem with that. Probably knew where I was going with this. For those who don't, just want to back up. Reg A provides a limited exemption from registration under the Securities Act to allow companies to raise money from the public as long as they meet specific requirements. So let's say you're a small public company. And in fact, there's 10 that I'm going to note. It was CW Petroleum Corp, DNA Brands, Greystone Company, Greenstream Holdings, Hemp Naturals, Livewire, Principal Solar, SFL Maven, the Marquee Group, and Verdi Bio Holdings. And they kind of announced all these 10 actions in a bunch, all 10 of them combined. Full disclosure, our firm actually represented 2. The point is that, what did they do wrong here? They just wanted to do a Reg A, and according to the SEC, each of them obtained qualification from the SEC. But then they subsequently made one or more, quote unquote, significant changes to those offerings without meeting the requirements. And what were those? According to the SEC, I'm getting to the point here, it was never tested. According to the SEC, those changes included improperly increasing the shares, improperly increasing the price of the shares, failing to file updated financial statements, engaging in prohibited at the market offerings, or engaging in prohibited delayed offerings. Now, look, I don't know about all of those cases. I said we were involved in some. Maybe those facts that the SEC alleges are true. That could be those companies. $5,000 civil penalty, $10,000 civil penalty. When they're going to give you a settlement that small, who wouldn't take it? Of course you would take a $5,000 penalty. But what does it come with? And this is the key. It comes with an injunction, a cease and desist order. So you can't do transactions like that anymore. They're not doing it for the $5,000. And trust me, as a lawyer, you can't tell a client, don't take the SEC's deal, $5,000. You pay the $5,000. But suddenly, that injunction, it keeps you from going. it keeps you from the next Reg A. So we've taken out the convertible lenders. We've taken out your Reg A filings. Let's pretend I didn't do that. Let's pretend everything worked out great. So, okay, somehow everything's terrific and somebody has their shares. You just want to sell your shares and make a little bit of money. That's excellent. Congrats. This is spectacular. You go to Glendale. No, you go to, oh, that's right. You kind of can't go anywhere anymore. No one exists anymore that can sell your shares. You go to Gel. There's a bunch of names. You guys know them. And you can't sell your shares anymore. What you don't know is why. And who here knows the song Hotel California? Okay, that's because what FINRA's done is they get one of those injunctions and then against those guys, the people who want to sell you the shares. And then, so what do? They do the right thing. They go and they appeal it to the SEC. That's part of the process. They can't go to real court yet. You have to appeal to the SEC itself. The SEC could just say you lose. If the SEC says you lose, then you could go to court. But no, just like the Hotel of California, you can't check out. You can't leave. You can't go to a real court. The SEC doesn't actually say you lose because then you could go to court and you might win. Instead, what do they say? Oh, your appeal? We haven't decided it yet. I'm giving myself another 180 days. And then after that, again, another 180 days. And then again. And it goes on and on and on, year after year after year, ad infinitum. It doesn't end. All they want to do is lose so that they can go and ask a court, hey, was this fair? And then, even if they lose there, then they could go back into business and actually sell your shares. The SEC doesn't want to win. They want to keep those brokers locked up so that they can't sell shares. So those are my three problem areas. We're dealing with enforcement right now. Those are the hot topics right now. And again, the purpose is very clear. It's to take out the microcap security space. It's to take out everybody here at Planet MicroCap. It's a problem. I don't have a ton of time left. Are there any questions?
What's the answer? And what would you say to a college student that thinks they want to get into this business, is about to graduate? Oh, I don't want to be investment banking. I want to work with small public companies. What's the advice for that college student?
It's easy for me to say, but I would tell them absolutely do it because it is still one of the most rewarding type of fields. I fell into this by accident and I am so glad that I did. I love the kind of people we get to work with. I love the kind of cases we get. And again, it's easy for me to say I'm not the one being sued, but we have had a lot of luck. You know, in general, I'm pointing out the problems and I'm pointing out the success that the enforcement has made, but and catch up to me later. There have been wins. We recently actually just got a Jed Rakoff, you've probably heard of him from the Southern District, to look at the specific factual basis. I don't want to name the case because it's an active pending case. We could go to trial in September, but no, there's absolutely still hope. That's, I guess, my answer there. And I would definitely, whoever that person is, if they're a real person, tell them to go into it. Can't get a better job. You may make more money doing something else, but it's not as much fun. What do you got? No, I think they existed beforehand, and I think they're going to exist now. I think this is not political. I mean, I think that's the wrong word for it. It's has nothing to do with politics. It's been around since the 90s when probably before. I started doing this in the 90s. There was just, everybody told me, no. Penny stocks, microcaps, they're bad. I was like, why? What? So it's 7 people instead of 700,000 people. What's the difference? No difference. Well, that's what they'll tell you. It's BS, but yeah. The question was, they want to put people out of business to protect the investors. That is the standard line we get from the regulators. I don't believe it for a second, and I don't think he does either. He knows better than that. Given the cases we've worked on, we've actually had access to some of the lists. Sadly, the only separation between the bad actors and the good actors is that the bad ones are on top of that list. Virtually every BD or investment bank that works in the microcap space, it's there. Virtually every lender who lends to the microcap space, it's there. And an awful lot of the public companies and the common, a lot of guys, they're the same CEO for multiple companies, things like that. They're all on those lists. They have lists because they want to they want to take out the industry, Shelley. We're doing what we can to stand in the way. And again, we've made some headway that I can't talk about, but we're doing pretty well. I don't know how much time I got left. About a minute. Tell you what, I'm going to use my minute instead of another question. If you have another question, please come up to me. Here for today, here for tomorrow, taking a red eye home. And if you can't get a hold of me for whatever reason, PULLP, PULLP, pulp.com, and you can get in touch with us that way. Thank you, everyone, for being here. Thank you, all of you.